All right, we're going to continue on talking about the judiciary, and specifically we want to talk about what types of cases are brought before the courts in the federal judiciary system. Well, first of all, there's criminal cases. Okay, and so criminal cases are those in which decisions are made regarding whether or not we need to punish individuals because they're accused of violating the state or federal criminal code. Okay, and these are the types of cases that we normally see on the TV shows. This is your murders, your home invasions, your burglary, your robberies, your rape, all those types of cases. Okay. Then you have civil cases. These are non-criminal cases where you're going to sue somebody in court and you bring them to court to resolve some dispute among individuals or parties, usually over finances, property, or personal well-being. This is your Judge Judy or any of those other shows you watch on TV that have, a small claims court. But some of these claims are very large, and so some very big civil cases. So Aaron Brockovich, if you watch that movie, that dealt with suing a plant that was involved with contaminating the water supply. So people were sued for personal damages. The other type of case is a plea bargain, and this is where the state presses to either reduce a sentence or charges in return for a guilty plea. And we see this a lot again on the TV shows where someone is going to plead guilty to a lesser crime, and they're usually going to give some sort of testimony against someone else in order to receive this reduced sentence. Okay. Then we hear a lot about class action suits. And again, the Aaron Brockovich movie was about a class action. A lot of tobacco cases are class action suits. And this is where there's a single civil case in which the plaintiff represents a whole class of people that have a similar situation, and the court's results apply to the entire class. So for example, it was a class action suit when a flight attendant sued the airlines for damages brought about due to smoking in the cabins, and so many of them developed lung cancer, and they sued the airlines and the tobacco companies in order to receive some sort of compensation. So a lot of tobacco cases against pharmaceutical companies, those are types of class action suits. All right, let's go back and talk to specifically criminal law and the criminal cases. So this is the part of the law, the branch of law that talks about how we're going to regulate the conduct of individuals, define what kind of crimes exist, and then give what kind of punishment is going to occur for that particular criminal act. All right. So in these types of cases, the government is always the plaintiff. So it's the government who brings charges against an individual. So if individual A murders individual B, B's family doesn't bring the people to court, the government does. So criminal cases, the plaintiff is the government. You are committing a crime against the state. Yes, you've killed another individual if this is what is being under investigation, and that family may sue you in criminal court, but the state is bringing the charges, so the government is always the plaintiff. In these types of cases, the defendant cannot be forced to testify. This is your Fifth Amendment right not to self-incriminate. So this is why you see in criminal cases a lot of times why the defendant is not testifying. The standard that is held is that you have to show that an individual, or the jury does, that the individual is guilty beyond a reasonable doubt. Okay. And the types of penalties, there could be fines involved. There could be that you're sentenced to so much time of public service and a fine. You could be you could be imprisoned for a certain amount of time, or in certain cases there would be the death penalty. The federal court system has the death penalty. Not all states do, but if you're found guilty in a federal court of a capital offense, you could be facing the death penalty. And this is, think of the Timothy McVeigh case and the bombing in Oklahoma. Timothy McVeigh was tried in a federal court because the crime he committed occurred on federal property, the Murray building. It was housed federal offices, and this is why it wound up in federal court. And he was put to death due to the sentence brought down by the jury. All right. In civil law, this is that branch of law that deals with disputes that don't involve criminal penalties, and here is when you're usually suing another individual. So the plaintiff, the person bringing the charges, is that party that believes that they have been legally wronged somehow. Your neighbor's dog keeps chewing up your lawn. You want to sue them for trespass. You feel like you've been wronged through some sort of business arrangement, so you're going to sue your former partner. Okay. The defendant can be forced to testify in a civil case. And here the standard is not as high as it is in the criminal court. The standard of guilt is a preponderance of evidence. And the penalty is typically monetary. You generally do not get thrown in jail for being found guilty of a civil crime. You have to pay damages. All right, so let's start talking about how the different courts are structured and how they relate to the state court system that we'll talk about next time. So again, we have a dual structure of the American court system. On the left-hand side is the federal court system. And so again, once again, at the very bottom you have the trial court level. Those are those U.S. district courts, and we have them in Texas. Every state must have at least one U.S. district court. So you create a federal crime, you go to U.S. Federal District Court. How do you know if it's a federal crime? If you're committing a crime on federal property, if you cross the state, you become a federal crime. If you kidnap and bring someone across the state, that's in federal court. So there's different ways that you wind up in federal court. If you lose the case here, you go to the U.S. Courts of Appeals. You lose your case here, you go to the U.S. Supreme Court. Okay. And they hear approximately 96 to 100 cases a year. So obviously, all these different cases don't wind up in the U.S. Supreme Court. There's a parallel system occurring at the state court. Okay? More than 99% of all cases are heard right here at the state court. You can see here probably over 89 million filings a year. So the state trial courts is where 99% of all cases in the United States are heard. The overwhelming majority of criminal cases involved in violation of state law, such as murder, robbery, fraud, theft, assault, all of that starts right here in the trial court. And although each state has its own set of laws, these laws have much in common from state to state. So criminal law may and does vary, for example, from state to state. Not all states have capital punishment. Prostitution is allowed in the state of Nevada. I mean, there's different ways that the criminal code differs from state to state, but there's a lot more in common than there is different. Okay. Another area where there's a lot of discrepancy is in family law, so divorce and child custody, and there's a good deal of variance between the states. So again, 99% of all the cases heard in the United States start out here. Okay, if you lose your state trial, you'll probably go to an appeals court in your state, and then probably to this particular area here, the highest state court. And then if you lose here, you could jump over into the federal system. Okay. But again, down here, just to review, this is the courts of original jurisdiction. So if you've printed this out, you might want to give yourself time here to write in original jurisdiction. The trial court has original jurisdiction, and the state trial courts have original jurisdiction. Okay? And again, they involve the federal government as a party or the state as a party. Civil suits can also start here, depending on how much the civil suit is involved in terms of monetary. Okay. When it comes to the jury, the federal courts are required to provide a grand jury, and a grand jury hears the evidence and decides whether the defendant should even be indicted or tried. Okay. So before you even get brought to a district court, a grand jury is impaneled before your trial to see if there's even enough evidence to hold over to trial. And then you have a petty jury, a 12-member trial jury, in order to hear your case, and you have to have a unanimous jury decision. Okay. At this level, at the district court, you have one judge per case. Okay? This court discovers the facts, creates the record, and this is where you're either found innocent or guilty of criminal court at the federal level. Okay, so there's 89 district courts in 50 states. There's one in D.C. There's one in Puerto Rico. There's some territorial courts. So there's a total of 94 courts, and there are over 600 federal judges who are appointed by the president and confirmed by the Senate. So the president gets to appoint 600 judges. That doesn't mean that each new time the president is elected that he gets to nominate 600 new people. Remember, they have a job for life. So not all 600 positions are going to be open at any one time. None of these district courts cuts across state lines, and every state has at least one, as previously mentioned. So more popular states have more than one. So the state of Texas has 4, for example. Okay. So here is the geographic boundaries of the district courts. So if you lose here and want to go to the courts of appeals, it's regionally decided. So we are in the 5th Circuit. Okay. So roughly 10% of all those lower court cases are appealed and accepted for review at the federal appellate level. Okay. Federal law guarantees everyone has the right to an appeal, but that doesn't mean all the cases are going to be heard. Appellate judges estimate that 80% of all appeals are frivolous, that is, they're without any real basis. Ordinarily, no new facts are introduced at the appellate level. So they only consider the records that was created at the trial court and oral or written briefs by the attorneys that are submitting the appeal. So again, you can see the 4 different districts within the state of Texas. So there's the southern, the western, the eastern, and the northern. So there are 4 district courts in the state of Texas at the federal level. You can see California has an eastern, a northern, a central, and a southern. You can see New York, but all these other states here, they have 1 district court. So we have 4. Okay. That doesn't mean there's just 4 judges. There's rotation. This is just where they are. They're in Houston. If you lose your district case, you go to New Orleans. This is where the 5th Circuit of Appeals is located. Okay? So again, the country is divided into 12 districts. Because of its finality, certain safeguards are in place here. There's usually 3 judges on each appeal, and each circuit is assigned a Supreme Court justice as the circuit justice. Okay? And so you have each one of the districts represented on the Supreme Court by one of the judges, so that you have a safeguard to make sure that not one person is deciding the appeal. Okay? So that's geographically how it's arranged. Okay? Then, of course, you have the Supreme Court. The Supreme Court is the court of last resort regarding all federal laws, as well as the U.S. Constitution. And again, it's primarily an appellate jurisdiction, but it has original jurisdiction in those special cases that I listed in the previous lecture. Okay? So there is a Chief Justice, and then there are 8 Associate Justices. So John Roberts, this man right here, is the current Chief Justice of the Supreme Court. The Chief Justice doesn't have any more authority in the decision-making than his colleagues. Each justice counts as 1 vote, but the influence of the Chief Justice is dependent on his leadership ability. And he gets to decide who writes the majority opinion, and he gets to decide who's going to write certain opinions about each case. So it's primarily an appellate jurisdiction, but again, it has original jurisdiction in those cases that I had laid out before. All right. Well, how does the Supreme Court operate? About 10,000 appeals are made to the Supreme Court every year. Obviously, they don't hear all of those. Less than 1%, or about 80 to 100 cases, actually appear on the court's docket. And after they have been accepted for full review with oral argument, again, only 80, okay? So in the 2009-2010 term, for example, 8,150 cases were filed, 82 were heard, and 81 had decisions issued. All right, so how do you get to be one of the lucky 80? Okay. There are different ways that the case could reach the U.S. Supreme Court. In most cases, reach the Supreme Court by what is called a writ of certiorari, which means to make more certain. So the Supreme Court controls its own caseload through this certiorari process, that it decides which cases it wants to hear and then rejects all others. So the number one way the cases reach the Supreme Court is by the justice's discretion. Each judge has types of cases that they're interested in hearing about. But all petitions or writ of certiorari must meet two criteria. The case must come from a U.S. Court of Appeals, a special 3-judge court of military appeals, a district court, or a state court of last resort. So let me repeat that. The way the case must come is either through the U.S. Court of Appeals, one of those 12 districts, a special 3-judge court of military appeals, a district court, which is the trial court at the federal level, or a state court of last resort. So if you are in the state system and you've appealed to the highest court in the state and still want to appeal again, then you can appeal to the Supreme Court. Then the Supreme Court requires a lower federal or state court to turn over its records if it wants to hear the case. Okay. So the first criteria is that it has to come from one of those courts. The second criteria is it must involve a federal question. Okay. So to grant certiorari, the Supreme Court uses the rule of 4. That is, at least 4 justices must agree to hear the case. So again, a writ of certiorari has to involve an important federal question. Is it a civil right? Is a civil liberty at stake? The appellate courts have ruled differently on this law, and therefore it needs to be applied universally. And the federal government is filing the appeal. All right, so this is kind of the process. The justices meet twice weekly to decide what appeals it's going to accept. And so they have a list of things that they're interested in. It's a discussion list. And then the remainder of the cases are put on a dead list, which means that they're usually not going to be heard. Okay? So the 3 rules of access must be a controversy. Parties must have some sort of standing, and the cases must not be moot. Okay? What does this mean, these 3 rules of access? Article 3 of the Constitution and the Supreme Court decisions define judicial powers as extending only to cases and controversies. Therefore, the Supreme Court is only going to hear a case that has an actual controversy, not a hypothetical one. So lawyers can't appeal to the Supreme Court and say, if I had a situation like this hypothetically, how would you rule? There has to be really 2 truly adversarial parties. So the courts don't have the power to render what are called advisory opinions. Okay, so they can only deal with cases that are actually controversial. Secondly, parties must show they have some sort of substantial stake in the outcome of the case. That means the parties who are bringing the case to the Supreme Court must show either injury to themselves personally, or obviously the injury can be economic, personal, or even aesthetically. Okay. This means that the general interest, let's say, in the environment does not provide a sufficient basis for standing. So you can't just bring frivolous lawsuits to the Supreme Court. Then the cases must not be moot. Well, what does this mean? Mootness. Mootness means that you're going to be able to disqualify cases that are brought too late, that is, after the relevant facts have changed or the problem has been resolved for other means. So to be moot means it doesn't matter anymore. It means to be rendered pointless. Okay? There are going to be times when the court is going to relax the requirement of this moot policy. And the most famous example is Roe v. Wade. In Roe v. Wade, the Supreme Court rejected a lower court's ruling that the case was moot since the pregnancy had already come to term. So Roe v. Wade is the case that brought about the legalization of abortions under certain conditions. By the time that court case reached the Supreme Court, the woman who brought the suit had already had her baby. All right, and so we can think about, there are cases that take so long to reach the Supreme Court, the court is willing to relax that particular rule of access so that they can hear the merits of the case to be able to make a particular law universally applied. Okay. So let's recap momentarily. You want to get your case to the Supreme Court, it's done through this writ of certiorari. Okay. It's a process where you have to have certain types of criteria. I listed two main ones. It must come from a lower court, a district court, or a state of court of last resort, and it has to involve a federal question. That's what this is talking about right here. It's an important question at stake, and the court wants to have it applied universally. And obviously the federal government is filing the appeal if they are the ones losing the case. Okay. The process is the justices meet, they decide what kind of cases they want to put on the discuss list and what kind of cases they want to put on the dead list, and then they go through these three rules of access. Does each one of these cases have a controversy? Do the parties bring in the case? Do they have standing? Is it a case that's no longer important? Okay. And then there's some other supporting players who are involved in this process, who are the different actors involved with bringing cases to the Supreme Court. And one of them is the Solicitor General of the United States. The Solicitor General is the third-ranking official in the Justice Department, and they influences which cases reach the Supreme Court. Oftentimes, the Solicitor General is known as the 10th Justice. This is an appointed position. It's the federal government's top lawyer, if you will. And they are the ones that are going to argue on behalf of the government before the Supreme Court. Okay? So when the Solicitor General requests a writ of certiorari, the justices take that request really seriously. So it is the Solicitor General which decides which federal cases to appeal from the lower courts. He's going to prepare those appeals, files the briefs, appears before the Supreme Court for oral arguments. Okay. And so this is a very important component or an actor in federal cases that are brought to the Supreme Court. Other actors that are obviously involved in this process that are part of the federal government is the FBI. You wouldn't think so very often, but the FBI provides a lot of data for for numerous government cases against businesses, individual citizens, state and local government. So the Solicitor General might use the FBI and the documents and data gathered by the FBI for their cases. And then there are law clerks who research the legal issues and assist with the preparations and opinions of the courts. Okay. There's going to be a few informal criteria that the judges use besides this writ of certiorari, and this is when the Supreme Court is going to hear cases that involve conflicting decisions by the federal circuit courts. So for example, let me go back to our map right quick. Oftentimes these different circuit judges have different political views, and so the Ninth Circuit is known as a fairly liberal circuit, and the southern districts are known as much more conservative. So if a case comes out of California and hits the circuit court that rules one way, and a similar case comes out of the 5th District that's ruled in another way, then you have conflicting decisions by the federal circuit courts, and that's when the Supreme Court is going to want to hear that case. A second informal criteria is if it involves a question of civil rights and civil liberties. So again, it's this issue right here that the courts are interested in. Obviously, if the federal government is one of the appellants, and this is the influence of the Solicitor General. And then lastly, justices have their own preferences and priorities. So now that there are 3 women on the Supreme Court, it could be that there's a lot of issues dealing with gender that are going to be brought before the Supreme Court. Certain judges are known as being more environmentally interested. We have judges that are more interested in business. And so different cases are brought before the court that justices want to hear because they have a personal interest in that. Okay. This ends part 1 of the judiciary, so make sure you review the reading questions and key terms. And again, there's some practice quizzes. And our next lecture is going to be about the judicial decision-making process and the politics involved of the federal judiciary.